If you're here to see us about a DWI case, one of the first things you realize was the police officer took your driver's license away. And he gave you a temporary driving permit, or at least he was supposed to. It's a piece of paper that says temporary driving permit on it, and for all purposes, it is your driver's license. And what is important about that piece of paper is on the bottom it tells you about your appellate rights, or your right to appeal that suspension of your license. It is an automatic suspension if you failed to give breath or blood upon a police officer's request, or if you took the breath or blood test and the result was a .08 or greater. Now, if you received that piece of paper and they took away your license, you have 15 days from the date of your arrest to file the appeal of that suspension. We do that as part of our representation, and we handle every bit of the expenses associated with that. What we have to do is notify DPS within 15 days of your arrest that we are appealing the suspension. Once we file that appeal, DPS keeps your license in clear status until we have your hearing. In other words, if you don't file the appeal, 40 days after your arrest, your license is automatically suspended. Now, once we file the appeal, your license is considered clear and valid until that hearing is held. Should it take 40 days or 60 days or 9 months or a year, your license is fine until we have that hearing. So make sure we get that information from you prior to the 15th day so we don't waste that opportunity. If we have the ALR, the Administrative License Review hearing of your driver's license suspension, the appeal, then what we can do is get the police officer in the courtroom, the administrative courtroom. It's not your criminal courtroom where your DWI will be held. It's in a separate building run by DPS and the State Office of Administrative Hearings. And what we'll do at that hearing is pin the officer down as to whether or not he had the right to stop you, the right to talk to you, the right to pull you over. If we can show that he did not have legal authority to do so, we'll win your driver's license case at that point. We'll also question him about the facts leading up to whether or not he had probable cause to make the arrest in your case. If he didn't have probable cause to make the arrest, your driver's license is safe. That suspension of your license case will be tossed out. Another thing we'll do is make sure that he read the paperwork properly. Did he read the proper paperwork? Did he unduly influence you, adding things that aren't in the paperwork? Any one of these issues can result in you being allowed to keep your license and the case being thrown out against you in the driver's license hearing. Now, the DWI case would still proceed in the criminal courthouse, but another thing that's valuable to us is if we get to cross-examine the police officer in the driver's license hearing, he is under oath. We can get a record, a certified record. Anything and everything that was said in that driver's license hearing can be used to impeach the officer later in case he tries to fabricate or make up or add in some new facts that he just happens to remember that aren't in the record, aren't on his police report, or they are not in the videotape, and we can lock them down and keep that from happening. We do see that less experienced lawyers sometimes fail to have that ALR hearing. They fail to ask the right questions to tie the officer down to his report or to the videotape, if there is one. And by losing that opportunity, they've cost their client dearly. I can tell you that as a former police officer, I witnessed numerous times officers making up testimony as they went. Sometimes officers get confused on cases. They'll be describing an arrest they made a month before or after your case. But yet if the lawyer doesn't do the adequate job of cross-examining, of pinning them down, and of locking them in their testimony, that can be overlooked, and you could actually be found guilty based on facts in someone else's case. This is especially true in San Antonio because in more than half of our cases, there is no videotape evidence. It's the officer coming to court, maybe a year later, maybe 2, 3, 4 years after an arrest, and he is testifying solely from his police report. And it's pretty easy for them to start making up some memories about things you did that hurt your case, or perhaps an admission of guilt, or some other actions that we have no other proof of except the officer suddenly remembering them in a courtroom. That does not happen to this law office. We lock them in and we pin them down up front, and they know that if they tried to pull those type of tactics on us, we have ways to deal with that. I know how to pull out their bag of tricks and shake it out empty in front of a jury. It hurts their case. I can tell you I have gotten not guilties before in trials. I believe in my heart of hearts it's because the police officer tried to play games on the stand. The jury saw through it. He lost all credibility, and they threw out every bit of evidence, testimony that he gave, and acquitted my clients. It's happened more than once. Acquitted my clients because of the actions of the police officer. I've also had cases in which I believe that a judge was so over the top being prejudicial towards myself and my client during the trial that the jury got angry, and the jury was willing to listen to well-documented, well-reasoned arguments on my part and the testimony of my client. They trusted my client and they found him not guilty. And what started the ball rolling in our direction was the fact that they told me later they felt like the judge was being unfair. They felt like the judge did not want to hear our side, but yet the jury wanted to hear our side, and that's what counts.